What if I told you that one of the most dangerous legal parasites in American tech history, a guy that has filed over 1,200 lawsuits, decided to go after the one and only Gabe Newell? And not just go after him, but do it twice, using patents he had already sold Valve the rights to. And what if I told you that his lawyers, when scrambling to put together a defense, handed the court a legal brief stuffed with 13 completely made up case citations, hallucinated wholesale by an AI that nobody bothered to double check. And that on February 17th, 2026, a jury in Seattle looked at all of it and sided with Valve on every single count. Yes, ladies and gentlemen, mostly gentlemen, this actually happened. Stick around because this is a wild one and it matters way beyond just Steam. It's fantastic. You gotta love it. Steam wins again. Let's get into it. All right, before we get into the actual lawsuit itself, I think you need to understand just how big of a bully Leigh Rothschild is, because if you don't know his name, you absolutely know his type. Rothschild is what the legal world calls a patent troll. Why isn't he working for Nintendo? Oh, maybe he is. He's so prolific at it that calling him a troll even feels like an understatement. He holds hundreds of patents across dozens of technology fields, and here's the thing, he doesn't actually make anything with them. He doesn't build products, he doesn't ship software, he doesn't run a real operating business, but what he does is exclusively file lawsuits or threaten to file them against companies that do build things and claiming they've somehow infringed on his intellectual property. So scum of the earth. So back in 2011, Rothschild staked a claim to something called the Rothschild Broadcasting Distribution System, or RBDS. The core patent, US patent number 8856221, a lot of numbers there, describes, and I'm paraphrasing here, a system for storing broadcast content in a cloud-based computing environment, which is vague, to say the least. Probably the point, because it's broad enough to hit a huge range of services. Over the years, Rothschild and his network of shell companies have gone after Apple, streaming platforms, small businesses, and like you name it, with over 1,200 lawsuits in total. The strategy was always simple but brutal. Most companies, especially smaller ones, find it cheaper and faster to just pay him to go away instead of fighting him in court. So that's what they do, and Rothschild gets paid, and then the cycle just continues until he ran into Valve. So back in 2016, Valve did exactly what everyone else does. They settled. They entered into what's formally called a Global Settlement and License Agreement, or a GSLA. Essentially, Valve handed Rothschild a very cartoonishly big bag of money. In exchange, Rothschild granted Valve a perpetual, irrevocable, royalty-free, fully paid-up worldwide license to his entire patent portfolio. Not just one patent either, guys. All of them, including patents that hadn't even been granted yet. So, translation here, Valve bought the legal right to never be sued by this man again, forever, for any patent he currently owned or would ever owe. It was essentially a peace treaty, and for years it held. Then, in 2022, one of Rothschild's shell companies called Display Technologies LLC sued Valve. They claimed that the Steam Deck and Steam itself infringed on a patent for displaying content. Lord bless me to not crash out right now. The old gods and the new. Valve's legal team responded by doing something almost poetic in its simplicity. They emailed Rothschild's lawyers a copy of the 2016 agreement and said, essentially, we already bought a license to this. Any reasonable person would look at that and be like, oh yeah, you're right, my bad, and then drop the case. And technically Rothschild's team did drop it eventually, dismissing it with prejudice, which kind of just means they legally cannot bring that specific claim ever again. But Valve wasn't done, because in 2023, Rothschild's lawyer sent another demand letter to Valve, this time about a different US patent with a long number, 8856221. which is the core RBDS patent, the one that Valve had explicitly licensed in 2016. This was the moment Valve decided it was done writing checks, done playing defense, and done just making the problem go away like a mother effing bamf. Valve sued back. But here's where it gets interesting, because Valve didn't just file a lawsuit against one of Rothschild's tiny little shell companies, they sued everyone. They named Rothschild personally. They named the Rothschild Broadcast Distribution System LLC. They named Display Technologies LLC. They named Patent Asset Management LLC. They named his lawyer, Samuel Myler, and Myler Legal LLC. Every entity, the man himself, even the mother effing attorney. And the legal theory Valve used was sharp. They argued that all of these LLCs were effectively Rothschild's alter egos, and that the whole shell company network existed specifically to shield him from personal liability when his lawsuits failed. And they could prove that. Rothschild himself couldn't just let one of his LLCs take the hit and walk away untouched. He'd be on the hook himself. So this is the part that most people miss about why this case matters so much. Most patent troll battles end with a company fighting one LLC winning or losing, and the troll himself never facing personal consequences. Valve was trying to break that mold entirely, because breaking molds is what Valve does. Now, Valve filed their countersuit in Washington state, and that choice was deliberate, because Washington has something that most states don't: the Patent Troll Prevention Act, or PTPA. This law specifically targets bad faith patent enforcement, the practice of acquiring patents not to actually use them or protect genuine innovation, but solely to extract money through litigation threats, like what this little slimy, wormy snake is doing. It's one of the strongest anti-patent troll statutes in the entire country. And Rothschild's team immediately pushed back, arguing that Valve, as a private company, couldn't sue under the PTPA. They tried to frame the whole thing as a private contract dispute, but the judge rejected that argument, ruling that patent trolling is a matter of vital public interest and that Valve had every right to pursue the case under that law. That ruling alone was a significant moment, because it signaled the court was taking the public harm of patent trolling very seriously and not just treating it as a business squabble between two private parties, which is what they wanted it to be, right? Okay, so now we get to the moment that if you cover things like AI like I do, you will absolutely love this. This is the part that would be so funny if it weren't such a perfect illustration of what happens when people deploy AI tools without actually checking their output. Because in late 2025, as the case was progressing and Rothschild's legal team was scrambling to build their defense, they filed a legal motion with the court. And buried inside that motion were 13 legal citations, case references, precedents, the kind of things that courts rely on to evaluate arguments. The problem, this is so juicy, guys, the cases did not exist. They were AI hallucinations. Someone on Rothschild's legal team had apparently used a generative AI tool to help research case law, and the AI did what AI is kind of known to do. It very confidently invented citations that sounded real and had plausible sounding case names and completely fabricated outcomes, and whoever submitted that brief to the court apparently didn't do their job and verify every single one of them. They're making it very, very difficult to argue that people need to do the job of the AI if the people can't even check the AI. If we don't want to lose all our jobs to the AI, the people need to work hard to prove that they're better than the AI. This guy did not do that. This guy's making it worse for everybody. But luckily, the judge caught it and imposed beautiful sanctions on the defense team. The attorneys apologized before the trial even began. I want to be clear here. AI tools used responsibly in legal research can be genuinely helpful. The problem was the total absence of human verification. That is fairly often a problem with an over-reliance on AI. You cannot take AI output and submit it to a federal court as fact without actually checking on it. That's not an AI failure. That's a human failure using AI. And the timing in the middle of a case about bad faith conduct could not have been worse optics for Rothschild's team. It definitely did not help. On February 17th, 2026, a federal jury in Seattle did return their verdict that Valve won on every single count. The jury found that Rothschild's and his associated entities violated Washington's Patent Troll Prevention Act. They found violations of the Consumer Protection Act. They confirmed the breach of the 2016 licensing agreement twice, once for the 2022 lawsuit and once for the 2023 demand letter. And the court agreed that Rothschild shell companies were effectively his alter egos, meaning the liability didn't stop at the LLCs. Leigh Rothschild, the man himself, finally was personally on the hook. The damages were roughly $152,000, not a massive number on paper, and honestly, not the point. The point is precedent. Washington's Patent Troll Prevention Act had rarely faced a full jury trial before. This verdict tests the law in a way it hadn't been tested before. And the fact that personal liability was upheld, that the shell game didn't work, and that's the part that should terrify every patent troll operating in this space. So why should you care about this if you're a gamer, a developer, or just someone who uses Steam? Well, first, the direct impact, right? Patent trolls don't just waste corporate money. That waste gets passed on. I mean, look at Palworld, for example. When companies spend millions fighting bogus litigation, it eats resources that could go into development, into better pricing, into features. Every settlement Rothschild extracted from a tech company was money that company didn't spend on anything productive. And in the case of like Pocket Pair, Palworld, with Nintendo, it's very clear what Nintendo is trying to do. They are trying to kill the company. They want to kill their competition. I'm supporting Palworld. Pocket Pair, you must win this one. If Steam can win this, I believe in Pocket Pair. Anyway, second is the indie impact. Like with Pocket Pair, Rothschild and people like him, they didn't just go after giants. They would go after small developers, small studios, small software businesses, people who can't afford to fight back and have no choice but to pay up. A ruling that pierces the shell company veil and holds the individual accountable makes that business model significantly riskier. Third is the industry-wide signal. We've seen a wave of patent aggression in gaming recently. Again, with Nintendo and their aggressive IP enforcement, Sony's got its own battles. You even have broad patents being weaponized against indie developers. The Valve ruling doesn't fix all of that, but it adds a powerful legal tool to the arsenal of companies willing to fight back rather than just settle. And fourth, and this is the part that I find to be most interesting, Valve did something most major corporations simply won't do. They spent more money fighting this bully than the settlement would have cost. They did it to set an example, and that's rare. That's Gabe Newell doing Gabe Newell things and deciding this was worth it on principle, not just on the balance sheet. And that matters because the reason patent trolling works is that fighting is always more expensive than settling. Valve just demonstrated that sometimes the most expensive thing you can do is let it slide. Rothschild's legal exposure isn't fully resolved yet, and damages are still being determined by the jury process, and there may be appeals, but the core findings stand. He violated the law, he violated the contract, and his shell company structure didn't protect him. For Valve, they go back to doing what they do. Steam remains the dominant PC storefront. The Steam Deck has genuinely changed portable gaming. A deadlock is in development. Life goes on. But the legal landscape has shifted at least a little bit. And other companies in Washington state now have a tested template for using the PTPA to find bad faith patent claims. Other jurisdictions may look at this verdict as a model, and every patent troll calculating whether to sue a company will now have to factor in the possibility that their target doesn't blink, doesn't settle, and comes after them personally. That's the legacy of this case, not the $152,000. It hasn't solved the whole problem. It's just a demonstration that the shell game has a counter move and that those who have the ability to can stand up to them. Now look, patent law, I get it, isn't exactly the most glamorous topic in gaming coverage, But cases like this one shape the environment that every developer, every platform, and every gamer operates in. The rules around intellectual property, around who can sue who for what, and determine what gets built and who gets paid and who gets squeezed out. Like, these are important topics, and Valve fought this one when they didn't have to, and they won. I'm hoping they win their new one with the UK, because we all know exactly what's going on there. But if you want more videos like this, I'm not a lawyer, but I cover gaming, technology, AI. I'm gonna be starting a series on agentic programming because I do software development and it's a skill I need to learn, and I'm sure you can all learn it with me. I'm also coming out with a video on Palantir if you'd like to hear a little bit of the tech conspiracy theories, because at my heart, I do love me a good tech conspiracy theory. And if you do like that, please go ahead and hit that like button and subscribe. If you don't, I might be forced to banish you to the Shadow Realm. No. Anyway, that's all I've got for you today. Thank you so much for watching. I hope you have a fantastic rest of your day, and peace out.